Ladies and gentlemen, welcome to our second day of the East Africa International Arbitration Conference 2020. Thank you for joining us virtually. We are very happy to have you. You have stayed with us since Wednesday, yesterday, and today, and we appreciate it. I would like to start off this session, which is our keynote session, by introducing a very, very important person to us, and that is Mr. Slim Abdallah, who is the president of the Zanzibar Law Society. As you all know, the East Africa International Arbitration Conference was meant to be in Zanzibar at this time, but due to the pandemic, we had to move it virtually. And we are privileged and honored to have Mr. Abdallah to grace our virtual conference and to give us his keynote remarks. Mr. Abdallah is an advocate of the High Court of Zanzibar and of Tanzania, and he is a member of the Zanzibar Law Society and the East Africa Law Society. He is well versed in investment laws, commercial laws, mergers and acquisitions, and he is the managing partner of Sepia Attorneys in Zanzibar. And with that, Mr. Abdallah, welcome, and please tell us your keynote remarks.
Thank you, Warimu, and thanks everyone. Thanks to everyone. Hello, how are you? My name is Slim Abdallah, is introduced by Ms. Warimu. Welcome to this few minutes of my speech. My speech is technically regarding the arbitration practice in Zanzibar. Zanzibar is a part of Tanzania, and mainly my presentation will touch on 5 areas. Firstly, is the key differences between Zanzibar arbitration practice and that of mainland Tanzania. Secondly, arbitration among ZLS, Zanzibar Law Society's members. And the third place is Zanzibar Law Society measures and development in building practice among its members. ZLS expectation from the EAIAC conference in order to contribute to the ZLS goals in arbitration practice. And then I'll conclude with my paper by telling what is our inspiration for this session among ZLS members. Ladies and gentlemen, let me start with the arbitration legal framework of Zanzibar. Zanzibar, being a part of Tanzania, got its independence in 1964, and then it went into union with Tanzania mainland. Zanzibar has its own government, executive, its own court system, judiciary, and its own lawmaking organ known as House of Representatives. Zanzibar, therefore, has its own arbitration regime and policies in matters pertaining to arbitration, which are non-union matters. International conventions are entered by the union government, and after being ratified by the parliament of the union, then they've been tabled to House of Representatives for them to have a force of law in Zanzibar. Tanzania has signed and ratified many international conventions in relation to arbitration processes. But Zanzibar legal regime lags behind for not amending the laws or passed new ones to step in with the current international arbitration requirements. Arbitration plays a crucial role in settling investment and commercial disputes, while Zanzibar arbitration regime is outdated due to the fact that the arbitration legislations, the arbitration decree Cap 25 of 1928, the arbitration clauses protocol Cap 26, and arbitration of 1926, and the arbitration foreign awards decree Cap 27, Act number 16 of 1931, civil procedure decree Cap 8, number 17 of 1917, section 66, Schedule number 3, are outdated or passed before the international conventions and treaties were passed. The application of the laws did not envisage the current situation where multinational companies and investors can enter several contracts or invest without involving the government of Zanzibar. Section 66 and the rules made under Schedule number 3 of the Civil Procedure Decree, Cap 8 of the revised laws of Zanzibar. These were enacted during colonial times, even before some of the international conventions on trade, investments, arbitration, and related matters were passed. And the old laws have not been amended or new laws passed like in other East African countries. Arbitration has also been introduced in labor dispute handling under the Employment Act number 11 of 2005, and the rules made on how the dispute handling unit should conduct mediation and arbitration. Key differences in Zanzibar arbitration practice and that of mainland Tanzania. The Arbitration Decree Cap 25, Act number 7 of 1928, applies where one of the parties is the state of Zanzibar, as per section number 1, sub 2, which provides, I quote, this decree shall apply to a submission or an arbitration to which the government of the protectorate is a party. Likewise, the arbitration clause, Protocol Cap 26, Act number 14 of 1926, was passed in Zanzibar to give effect to the protocol on arbitration clauses passed by League of Nations on 24th of September 1923 to give validity in Zanzibar of commercial agreements to submit to arbitration in Zanzibar as per clause 1. Clause number 7 allowed a contracting state to denounce the protocol on giving a 1-year notice. It is debatable whether this protocol continues to apply following the revolution of Zanzibar and the subsequent union with Tanganyika and the formation of the United Republic of Tanzania. Also, the arbitration, Foreign Award Decree Cap 27, Act number 16 of 1931 was enacted in Zanzibar to enable awards made in pursuance of the arbitration protocol to be enforceable in Zanzibar as per section 3 and section 4. The award to be enforced should have been made by a tribunal agreed in the agreement. There are conditions therein which bars the enforcement if they are violated. Lastly, the Civil Procedure Decree, Cap 8 of the revised laws of Zanzibar, Act number 17 of 1917, under section 66, provide the rules where is reference in arbitration by order in a suit. The rules or provisions are contained in the third schedule. This is the only provision under which a non-state party may have recourse to arbitration with the supervision of the court. This means parties must file a suit before making reference to arbitration after complying with the rules. These rules were made under Article 40 of the Zanzibar Order in Council of 1924. Section 24 of the Repeal Courts Decree, Cap 3, and Section 110 of the Civil Procedure Decree, Cap 8. By comparison, the arbitration legislations of Kenya, Uganda, and mainland Tanzania, is formerly known as Tanganyika, were identical as they were coming from the same colonial master. This necessitates overhaul of the laws by enacting new ones to be in tandem with the current commercial operations and international conventions. Kenya has already passed a new law based on the United Nations Commission on International Trade Law, Model Law of 1986. It is the Arbitration Act, Cap 49 of revised edition of 2012. It is an act of Parliament to repeal and reenact with amendment the Arbitration Act and to provide for connected purposes, Act number 4 of 1995, Government Notice 394, stroke of 1995, Act number 11 of 2009. The Act applies to domestic arbitration and international arbitration. The Kenya Act has several parts. Part 1 defines and other primary matters and provides provision means any arbitration, whether or not administered by permanent arbitral institution. Arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. Arbitral award is any award of an arbitral tribunal and includes an interim arbitral award. Arbitral tribunal means a sole arbitrator or a panel of arbitrators. Party means a party to an arbitration agreement and includes a person claiming through or under a party. Ladies and gentlemen, Part 2 provides for general provisions, form of arbitration agreement, waiver of right of objects, stay of legal proceedings, interim measures by courts, death of a party, receipt of written communications, extent of court intervention, whereby Part 3 and Part 4 and Part 5, which provide recurs to High Court against arbitral award, application for setting aside the arbitral award, where Part 7 provide for recognition and enforcement of awards. Ladies and gentlemen, in Uganda, the situation is a bit different, whereby this country passed the Arbitration and Conciliation Act of 2010, which is the Chapter 4 of the laws of Uganda. This is an act to amend the law relating to domestic arbitration, international commercial arbitration, and enforcement of foreign arbitral awards. The Act in Part 4 provides for enforcement of ICSID convention awards. It provides for definition, registration, and enforcement. The Uganda Act in Part 5 provides for conciliation. In this part, the law provides for application and scope, commencement of conciliation proceedings, number of conciliators, appointment of conciliators, submission of a statement to conciliator, role of conciliator, communication between conciliator and parties, disclosure of information, cooperation of parties with conciliator, suggestion by parties for settlement of disputes and settlement agreements. The Uganda Act in Part 6, like Kenya, also provide the Center of Arbitration and Dispute Resolution. The case in Tanzania mainland, has already passed a bill into an act, which is now called Arbitration Act number 2020. It is current arbitration law, Cap 15 of revised or laws of mainland Tanzania. The current law provides in Part 1 preliminary provision, which comprises of short title and interpretation. There are Part 2, Part 3, and Part 5 and 6, in which Part 4 deals with the provision relating to the conventions set forth in the 4th schedule, which are the same like those provided in Cap 27 of the revised laws of Zanzibar. By comparison, arbitration laws of mainland Tanzania is parameteria with arbitration decree Cap 25 of the revised laws of Zanzibar, except that in Zanzibar, submission must involve the government of Zanzibar as a party. This means Kenya and Uganda have better arbitration regimes, and there are specific provisions with providing for convention which came into being after East African countries got their independence. In short, they have overhauled and updated the arbitral laws. Arbitration among Zanzibar Law Society members. As of now, Zanzibar has less than 10 registered advocates or arbitrators with an official recognition to practice in the arbitration industry. One reason among many is that Zanzibar as a state has never staged all what it takes to have arbitration practices possible, such as setting up the required legal framework. We have a scattered legislation on arbitration matters and not enough for enforcement. The other reason is that most of the lawyers in Zanzibar are not conversant with arbitration practices, and they never acquired knowledge, know-how on how to practice in this area. They're not even registered by any organization responsible for this practice, as the case is in Tanzania mainland. Zanzibar Law Society measures and development in building practice among its members. The ZLS, as the main umbrella which brings all advocates in Zanzibar under one roof, has been taking some measures aiming at making arbitration practices normal among its members. Among all these measures, including but not limited to: 1, encouraging arbitration mode of amicable settlement of matters among its advocates in all advocate congregations that discusses the best ways of legal practices. This includes but not limited to arbitration training in CLE's programs. Secondly, ZLS is taking some leading role while joining force with other development stakeholders, including some NGOs and including the Zanzibar National Chamber of Commerce, and advising the central government to pass an arbitration act for mainstreaming arbitration practices in Zanzibar. ZLS expectation from EAIAC conference in order to contribute to the ZLS goals in arbitration. Ladies and gentlemen, Zanzibar Law Society has a big expectation that this forum will inspire its members and push them into having provoking their desire in acquiring the knowledge in arbitration practice for the purpose of handling the commercial and commercial cases, investment matters in more speed, out of the court, which is time and financial demands. In concluding my paper, ladies and gentlemen, arbitration is a proper mechanism because once arbitral award is made, it is immediately enforceable both nationally and internationally in all state members of the treaty. Greater consideration are given to the arbitration since it is a confidential and flexible procedure which provides parties with the right to choose specific arbitrators with particular expertise and technicalities suitable for the disputes at stake. Arbitration also provides a time frame for adjudicating on a dispute. There are many reasons as to why Zanzibar arbitration decrees should be revised. This world has made greater changes to make the modern realities. As a party to the world, Zanzibar should be aligned with the other jurisdictions and provide certainty in speed adjudication of commercial and investment disputes. The changes need to incorporate the United Nations Commission on International Trade Law, arbitration rules with a special focus on rules of transparency in treaty-based investor-state arbitration, meaning the rules on transparency of 2013. That add new article 1, paragraph 4, the arbitration rules of 2010. The new edition provides utmost clarity in relation to its application, given that Tanzania is a signatory to the New York Conventions on Cognition and Enforcement of Foreign Arbitral Award of 1958. It creates a mandatory reason to make realization on the recognition and enforcement of foreign arbitral award. Ladies and gentlemen, it is our significant hope that this congregation will inspire and provoke the thought and demand for our advocates to change, to acquire arbitral knowledge, and come into same page whereby the regional regimes they are. Let me thank you all for listening and for your attention. Thank you so much.
Thank you very much, Mr. Slim Abdallah, the president of the Zanzibar Law Society, for taking us through the developments in Zanzibar and in Tanzania. And it is great to hear the strides that Tanzania is making with the new Arbitration Act and Zanzibar's progress in its legislation and Tanzania's accession to various international arbitration conventions. We look forward to bringing the East Africa Arbitration Conference, International Arbitration Conference, to Zanzibar in future. Once we have the pandemic sorted, we shall be sure to come to Zanzibar. Thank you very much.
You're welcome.